Welcome back to Political Connections, everybody. I'm David Bodden, and this is Common Ground. Just over 1 week ago, an announcement by 9th Judicial Circuit State Attorney Aramis Ayala regarding the pursuit or lack of pursuit of the death penalty set off a firestorm around the state. Listen in to what State Attorney Ayala said at that morning news conference.
Deciding when and if to seek death penalty is one of the most important decisions I will have to make in my capacity as state attorney. It is a serious decision with grave consequences for victims' families, for this community, and for defendants and their families. I have given this issue extensive and painstaking thought and consideration. What has become abundantly clear through this process is that while I currently do have discretion to pursue death sentences, I have determined that doing so is not in the best interest of this community or the best interest of justice.
Ayala also said that the cost to taxpayers and the ongoing legal battle all contributed to her decision. The announcement triggered multiple reactions.
And that is doing what she believes legally she should be doing and morally that she should be doing.
I don't think it speaks to anything about how this community values our police officers.
We have set strict guidelines in the legislature what they should follow to make that prosecutorial decisions. And she has not made it just this personal case. And any death cases coming forward, she said that she will not even consider trying them. And it goes against the spirit of the law that we set forward.
The death penalty is the law of the state of Florida for capital crime. I'm more concerned with the immediate situation of trying to convince the governor that what his options are and to get him to act. I think he's the first line on this, and I think we'll see him do so.
And Governor Scott did indeed act, issuing an order that removed Ayala from any cases involving Markeith Loyd, turning them over to State Attorney Brad King from the 5th Judicial Circuit. Now, in a statement, Governor Scott said this: "I am outraged and sickened by the loss of life, and many families' lives have been forever changed because of these senseless murders. These families deserve a state attorney who will aggressively prosecute Markeith Loyd to the fullest extent of the law, and justice must be served." Local lawmakers in Tallahassee also responded to Aramis Ayala's pledge not to seek the death penalty in any case by saying perhaps it's now time to bring up a new reform bill.
I've reached out to the members of the Florida legislature and our staff about the possibility of drafting legislation to ensure our laws are followed. I'm also seeking whether this is a possible violation of the public integrity of our state attorney.
Joining us now to talk about all of this is Michael Morley, Assistant Professor of Law at Barry University, and Leroy Purnell, Professor at Florida A&M College of Law. Gentlemen, thank you for being with us here today. Now, let's start with the State Attorney. Aramis Ayala, now, was she right or wrong in making this announcement?
Well, you know, it's difficult to say ultimately whether she was right or wrong with the decision, and I'm not going to second guess that. Certainly, in the court of public opinion, there would be a lot of opinion against her making the decision. I think the real question: did she have the power to make that decision? And I think that that's going to be the issue not only for this case but for the future of states' attorneys everywhere. Is what is the extent of the discretion that an elected prosecutor has?
Michael, your thoughts?
Prosecutorial discretion is all about deciding whether in a particular case certain laws were violated, certain sanctions should be sought. What the state's attorney did here goes far beyond the exercise of prosecutorial discretion on a case-by-case basis. She unilaterally decided that she disagreed with the death penalty, that she didn't think it was effective, that she thought it was too expensive, and so she substituted her own personal judgment for that of the state legislature by simply declaring across the board, no matter what the circumstances, she simply will refuse to seek the death penalty. That's wholly inappropriate for a prosecutor to do.
Now, this was a very highly visible case. Have anybody even noticed about this case if this had been not an accused cop killer case? Would anybody have even noticed what she said?
Well, it depends to some extent on if she'd come out with a blanket statement against the death penalty. There probably would have been some reaction, but certainly this particular case has high emotions involved, and I think it gets a lot more attention because of that. But let me say, I disagree with the statement about prosecutorial discretion. I think prosecutorial discretion as a principle is not limited to a case-by-case review. There are prosecutors in any, if we were not talking about this case, we were not talking about even necessarily the death penalty, there's a history throughout the country of prosecutorial discretion determining prosecutor policies regarding prosecutions of cases. I mean, take minor cases up to major cases. The real question becomes to what extent do we rein in that type of discretion? You know, the legislature is talking about some type of change on that. That's one thing. But as the law currently stands, prosecutorial discretion is still something that's lodged in the prosecutor's office. And really, we only interfere with that if there's misfeasance or malfeasance involved.
Michael, do you think we would have been talking about this had this not been an accused cop killer case? Absolutely.
I mean, even beyond the horrific murder of Lieutenant Clayton, we still had a pregnant woman who was allegedly murdered in cold blood. And let's not forget, our community is still reeling from the mass murder at the Pulse nightclub. So for the prosecutor here to say, no matter what, I categorically refuse to seek the death penalty against anyone, no matter what crimes they commit against our community, yes, I absolutely do think that would have received a tremendous amount of public attention. And in terms of prosecutorial discretion, even if you think that a law enforcement official, an executive official, can make that sort of determination, the fact remains our state constitution vests the governor with the ultimate executive power to take care that the laws be faithfully executed. So even if this is seen as a matter of executive discretion, constitutionally, under our state constitution, the governor certainly had the authority to decide that here the state's attorney was refusing to carry out the law, was refusing to execute the law, and so in an extreme case like this, he stepped in appropriately pursuant to state statute and substituted his own discretion, which was much more in line with what the legislature expected.
Okay, well then let me ask you this. On the tails of that response, did the governor overstep his authority?
Well, I think that there's a real question about that. Yes, there is removal from office language in the state constitution, but again, that language talks about removing a public official from their responsibility for specific reasons, malfeasance or misfeasance, primarily in office. So that is a question that's got to be decided probably by the courts and not by public opinion.
Does this also ignore the voters who voted her into office because of her views?
Well, this is also certainly a political question that's involved in terms that this is an elected official, and typically if the elected official is not doing the job that the public wants, the way that we handle that is we vote him out of office.
Your thoughts, Michael?
I couldn't disagree more. We have a state statute that clearly says for any good and sufficient reason, that's the exact language, any good and sufficient reason, if the governor decides that the ends of justice would best be served by substituting in one state's attorney for another, state law gives him that absolute discretion. And so here, citing that statute, the governor determined that yes, the ends of justice would be served by substituting in a state's attorney who is at least open to the possibility of following state law, who is at least open to looking at this case to decide whether the death penalty is appropriate. And the Florida Supreme Court has affirmed that broad discretion. The Florida Supreme Court, in interpreting the statute, expressly said governors have broad discretion in determining whether good and sufficient reasons exist, and it said that many situations might exist where even when a state's attorney is present, even when they appear capable or qualified, the governor may nevertheless decide that justice would be served by substituting in a replacement.
Well, let me ask you this. This is absolutely uncharted territory because we've not seen this before in the state of Florida. Does it set a dangerous precedent for state attorneys across the state of Florida? And will they be looking over their shoulders now at the decisions they make in prosecuting cases?
I think there certainly is that possibility and again, this is going to be determined by the courts. It's not going to be determined by public opinion. I don't think it's a clear-cut case, and I think that I don't know how that case comes out, but it does put a cloud then over prosecutors in terms of their decision-making, exercise of their decision-making power, so that there's going to need to be much clearer guidance given by the court if prosecutors are to exercise their traditional power of making discretionary, even if wrong, decisions.
Michael?
The precedent that was set here wasn't by the governor. The dangerous precedent was set by a prosecutor deciding, I disagree with a particular type of penalty, I disagree with the statute, so I'm simply going to refrain from enforcing it. The governor's actions were an appropriate response to that unprecedented step, were well within his authority under the state constitution, and constitute under state law a good and sufficient reason for, in his discretion, for replacing her.
Michael, let me ask you this. We're going to ask both of you, but Michael, let me start with you. What is the common ground here moving forward? Is there any common ground?
Well, I think that in part it depends on what the state attorney chooses to do. There have been some indications that she might attempt to try to fight the removal. I think that any attempt to fight the removal would fail. State Supreme Court precedent is clear about the governor's broad discretion. So as we move forward, as hopefully justice is done in the Markeith Loyd case, that will hopefully bring the community together and leave us with common ground.
What do you think?
I think we'll probably continue to be divided about this. I think the state's attorney probably is going to challenge. I don't know how that case is come out. I'm not necessarily convinced that that's a slam dunk for either side on that issue. I think that certainly there is precedent for using special prosecutors in different circumstances. I think in the short-term prediction in the Keith's case is that he'll probably be indicted with death penalty specifications. And that raises a whole nother set of problems that may come up there. But bear in mind that part of Ayala's decision isn't simply that I oppose a death penalty. Apparently her rationale is she weighed a number of factors, including resources, use of resources, and so forth, to reach a decision that, again, we may disagree with that decision. We may think that is not a rational choice, but the question then becomes, what choices do we leave prosecutors to make?
Very hot topic. And gentlemen, thank you so much for being here. Michael Morley and Leroy Purnell, thank you for joining us.
Thank you.